SJC-13739 in the matter of an impounded case.
Okay, Attorney Paris, whenever you're ready.
Thank you. Good morning. May it please the court. Molly Paris on behalf of the Commonwealth. The discrete issue before this court is whether an adjudication is required for a juvenile charged by delinquency complaint for violating Chapter 269, Section A. The answer is yes, and that's based on the plain reading of Chapter 269.10a and Chapter 119.58, Paragraph 7, which read in harmony shows the legislature's intent that an adjudication was always required because the legislature intended to treat firearm offenses differently than any other type of crime. Starting with the plain language of 269.10a, prosecutions commenced under this section shall not be continued without a finding. This substantive offense needs to be read in harmony with the sentencing statute in 119.58, Paragraph 7, which was enacted in 1996, which was the same year when the legislature added the Youthful Offender Act. That paragraph requires a judge to impose a mandatory minimum commitment to DYS for 180 days or until the juvenile's 18th birthday, whichever occurs first.
You skip over, though. You skip right to Paragraph 7. And the words of Paragraph 7 begin with, notwithstanding any other provisions of this chapter, a person adjudicated a delinquent child. Now, that means you have to look at Paragraph 1, and you need to make sense of, why does Paragraph 1 say, if the allegations against a child are proved beyond reasonable doubt, he may be adjudged a delinquent child, or in lieu thereof, the court may continue the case without a finding. So you have to make sense of that, because it doesn't make any sense to me that you're relying on Paragraph 7 where there's been no adjudication of delinquency, because pursuant to Paragraph 1, Judge Coyne said, I'm going to continue this matter without a finding, just like Paragraph 1 says I can, because I'm given an either-or proposition.
And I think the problem with that is that when you look at the statutory scheme as a whole, it would have been illogical for the legislature to have allowed quaffs on 10As for delinquency complaints and at the same time have required mandatory minimums and then precluded any sentencing option in between.
But we know when the legislature doesn't want a quaff in a juvenile case on the 265 offenses, they enumerate them, correct?
That's correct. But the difference is those 265 offenses don't have a mandatory minimum.
But they have the same language that you're relying on. They may not, the prosecution on those cases may not be terminated or whatever with a quaff.
That's true, Your Honor. But the difference is when you look at the juvenile sentencing statute, those 265 offenses don't have a mandatory minimum. So in other words, a judge, it would be illogical for the legislature to have required a mandatory minimum for firearm offenses, to have allowed a quaff, but not to allow for any other resolution.
Can we step back and consider what is a quaff and what is a conviction or delinquency adjudication? They're two separate things, correct? Mm-hmm.
Yes. So a quaff is a continuation without a finding of guilt,
right,
which can ripen into an adjudication.
Right. And that's, so if we go to adults, you're either convicted of a crime, and then if you have a quaff, you haven't been convicted of a crime, correct?
Correct.
And then in the juvenile situation, we have a delinquency adjudication, or in lieu thereof, a quaff, which means it's not a delinquency adjudication, correct?
Correct, but the legislature never intended quaffs on 10As, and that's because they imposed a mandatory minimum on 10As in Paragraph 7, and I would, direct the court to Paragraph 7, the strong language of notwithstanding any other provision in this chapter.
Keep going.
You have to keep going. A person adjudicated a delinquent child, and you don't have an adjudication of delinquency. So how do you get around that?
Because first of all, Paragraph 7 was added in 1996, which was before all the 265 offenses were added into Paragraph 1. We know that Paragraph 7 supersedes any provision, not only in Chapter 119.58, but throughout the whole chapter of 119. And just based on the context of what the legislature intended in 1996, which this court recognized in Connor C., where prior delinquency adjudications, in that case specifically, were considered convictions for subsequent.
I still don't see how Connor C. helps you. I get you what you're saying, but in Connor C., we were discussing whether or not that could be used as an enhancement. And in Connor C., there was an actual delinquency adjudication. Again, we're not there. There wasn't one. And this is because Judge Coyne said, I have either or. It seems like it says either or. The text says either or. So I'm still wondering why it is that we're saying, at least for your purposes of your argument, that a quaff is tantamount to an actual delinquency adjudication when nothing's happened to ripen it into a delinquency adjudication.
So a quaff isn't akin to a delinquency adjudication, but there's the juvenile and Judge Coyne are circumventing a loophole here, where if we look at the plain language of Chapter 11958, it would have been illogical for the legislature to have required a mandatory minimum on firearm offenses under Chapter 26910A, and at the same time have allowed for quaffs.
But don't they give the judge the option, though? They give a judge the option because they say under 58, you can either find someone delinquent,
Right.
or you can find someone, or you may quaff it in the alternative, correct?
That seems to be the harmony.
If we look at the second paragraph of 11958, for any other juvenile adjudication on a delinquency complaint, that juvenile, a judge could impose probation, continue the case without a finding, oppose DYS to any term.
But that's a consequence of an adjudication of delinquency, correct?
Correct. And what we know is that for
We
firearm,
haven't got there yet because we have a quaff in lieu thereof.
right, but I think if this court looks at the sentencing scheme as a whole and looks at what the legislature's intent was in 1996 when this was enacted, which was to punish firearm offenses more harshly, and we know that because it created paragraph 7 with this notwithstanding paragraph. We know that because Chapter 26910A is one of the only enumerated offenses.
I don't mean to interrupt you, but I still don't see the tension because it seems that that's harmonious with what we're saying, that if a judge finds that I am going to adjudicate this child as a delinquent, I have no option. I've got to impose the DYS commitment. That is just harmonious with, but if I don't, and I continue the matter without a finding, I don't have to do that.
I would respectfully disagree, Your Honor, because I think it would create an absurd result if the legislature had intended to allow such a lenient disposition as quaffs, and then for delinquency adjudications on 10A complaints have required a mandatory minimum of 180 days or until the juvenile's 18th birthday, which is significant. This is the only offense in Chapter 11958 where a mandatory minimum is required on juvenile adjudications.
Don't we have other examples of that? Where, like, I think it's armed home invasion, some other offenses where they say you can't put them on probation, et cetera, or they have language such that, and it's a 20-year offense, but a judge could put someone on probation. They don't have to do it, but if they sentence them, it's going to be 20 years. Aren't you aware of other?
I am aware, Your Honor, but I would distinguish that because that's in the adult context, whereas here we're strictly
Well, no,
dealing with.
but I'm talking about what makes sense, because you have staircasing that the legislature has set out, and what you say is that you can't go to quaff. It has to be an adjudication, essentially.
Yes, I think it would be illogical for the legislature to, on the one hand, have allowed quaffs on the most lenient side of a spectrum, to then have allowed.
Right, which is what they do in the 265 context. Correct.
I would.
For juveniles, when they want to say no quaffs, no ifs, ands, or buts, that's in the 265
So
enumerated offenses, right?
yes, but I would distinguish that because in Chapter 1, the legislature has said 265 offenses are serious enough so that we're going to preclude quaffs. We're going to expressly preclude quaffs, but they're not serious enough so that we're going to require a mandatory minimum or restrict any other sentencing options. And we know that because if we go to 11950 Section 2 for any other adjudications, including Chapter 265 offenses, a judge has those other options at their disposal to impose.
Counsel, can I ask you a related question to a word you used a few minutes ago? So you used the word loophole a couple of minutes ago in your argument. And the way you're puzzling through all these different pieces to kind of convince us that this is pretty clear, it seems to me that there at least is the argument that this is ambiguous. And if that's the case, because it's not, if you have got to go through all this kind of Rube Goldberg kind of way of kind of getting to us to tell us that this is, black and white and you can't do it. If it's ambiguous, doesn't the rule of lenity militate in favor of Judge Coyne's ability to do this?
I would suggest, Your Honor, that the rule of lenity does not apply because the language of the statute is clear.
Say we disagree with you.
Then yes, the rule of lenity does apply. Okay. But I would suggest in this case, it does not apply. And I think it would have been superfluous for the legislature to have added 26910A into paragraph 1 and expressly said no quaffs, because it was always the legislature's intent to treat firearm offenses more harshly. And that's because they created paragraph 7 in the same year that they added 26910A as one of the few offenses, possessory offenses, for which an individual could be indicted as a youthful offender. So someone as young as 14 could face an adult sentence, which in this case.
Right, if they're adjudicated.
But that's your call. That's the DA's call, correct?
Yes, but I think the legislature was aware in constructing this, that especially in a case like this where the juvenile brought.
Right, so if you think it's a serious case, you don't want to quaff, you have the ability to YO the case, correct?
That's correct. In certain circumstances, should that individual meet the age requirements of 14 to 18. But I think, again, what the legislature was getting at is exactly what they wanted to stop in this case, which was an individual who brought a gun to school.
So if your office thinks that it's egregious, like you could argue it's here, they brought a gun to school, they can go to the grand jury, correct? And YO it.
Correct, for certain individuals, depending on their age, but also perhaps it could have been as a prosecutor's decision to not subject that individual to possible adult punishment, because if they're indicted as a youthful offender, they face, of those 3 dispositional options, adult punishment. So again, I would just suggest that where the legislature has shown its clear intent to treat firearm offenses more harshly, the fact that.
Can I ask about 265 for a second? So the enumerated offenses all involve violence, right? Is that right? Or
I would
either sexual or other or violence?
They're typically all sexual assault cases, sexual assault crimes.
So does that also inform that maybe the legislature said, okay, we've got contact offenses as opposed to a gun possession, so they didn't put the gun possession into that statute?
Well, I think what the legislature realized after it added paragraph 7 into 11958 in 1996 was that certain offenses on juvenile delinquency complaints could not receive a quaff, but those Chapter 265 offenses were not serious enough such that the legislature intended to impose a mandatory minimum. Because again, if a juvenile is adjudicated delinquent on any of those 265 offenses, they can receive probation. They could receive DYS for 1 week, as opposed to the delinquency on the 10A, which requires 180 days or until the juvenile's 18th birthday as the minimum. A judge could, of course, increase that within their discretion. And I think that's significant. And the notwithstanding clause, not only is paragraph 7 notwithstanding any other provision in this section, it's of this chapter, which almost suggests that it is trying to distance itself from 11953's liberal construction mandate.
Is Commonwealth no longer pressing its argument under 26910 and the sentence that says prosecutions commenced under this subsection shall neither be continued nor without a finding nor placed on file?
To answer, Your Honor, I think that language helps inform how this court views the overall statutory scheme. I think we need to read everything in harmony.
Are you, all right, so can you, if that's the case, can you help me with the word prosecution? How are we to understand that? Or how are we to understand that to include delinquency complaints? Where would we go for some guidance on what's included within the word prosecution?
If I might answer. Yes, so I think that just involves that once a prosecutor brings a complaint, once an individual is charged under 26910A, there needs to be an adjudication. There needs to be some finality to that resolution. It can't be left open with a quaff. It's dealing with whether an adjudication is required or not. It's not about whether the substantive offense in this case is controlling the ultimate sentencing. As it just so happens, when we go to 11958, paragraph 7 does to some extent limit a judge's discretion by imposing that mandatory minimum, but of course the judge has discretion to increase that.
Can I ask one more question? Sorry, Chief. On paragraph, you say paragraph 7 was added in 96?
It was.
Okay. At the time it was added, did paragraph 1 exist?
Paragraph 1 existed, but none of those chapter 265 offenses were added.
But the point, my question is not about those 265 excluded offenses, but paragraph 1 gave judges in the juvenile court the choice to adjudicate, I guess, a delinquent child, or in lieu thereof, quaff.
That's correct.
Okay, so just freeze framing in 1996, what the legislature had in mind was they knew that juvenile judges had this choice between an actual adjudication of delinquency versus quaffing. And then in paragraph 7, when they sat down, pen to paper to write it, they talked about the situation where a juvenile court judge adjudicated somebody delinquent. They didn't deal with the quaffs.
They didn't, but the implication there is that by expressly carving out paragraph 7 and using that notwithstanding clause, it would have created an absurd result for the legislature to have intended quaffs, the most lenient disposition for 10A offenses, and then at the same time have allowed for the harshest sentence.
Wouldn't it have made more sense, if you're right, for the legislature then to have said, where there's, if the allegations of a child are proved against a child are proved beyond a reasonable doubt in connection with 10A, then 180 days. That would have been clearer.
Sure, the statute could have been written more clear, but when we have this.
But instead, they took option B, adjudicated delinquency, and dealt with only that option, not the other option, quaffing.
Correct, because it would have created an absurd result to have allowed quaffs.
Okay, thank you.
Thank you.
Thank you. Okay, Attorney Tassel.
Good morning, ladies and gentlemen. Neil Tassel on behalf of the juvenile. I represent the juvenile before Judge Coyne in the Boston Juvenile Court. Since 1975, the legislature has provided for a mechanism, the Commonwealth might refer to it as a loophole, but a mechanism by which juveniles can be treated differently than adults for the consequences of violation of Chapter 26910A. Since at least 1996, the legislature has specifically permitted continuations without a finding. And that change occurred at the same time as the Commonwealth indicates when transfer was removed from the statute and the authority to indict cases was given to the Commonwealth for youthful offenders. The concept that children should be treated differently than adults is baked in throughout the juvenile code. The goals are primarily rehabilitative, cognizant of the differences between juveniles and adult offenders, and the goal is to essentially redeem and educate rather than punish.
I think we know.
I'm sorry, so the consequence is going to be more YO charges, correct?
Correct, and the irony that the Commonwealth's point brings up, and to your point that was asked of the Commonwealth, if they wanted to indict the person as a youthful offender, they could. But now, as of 2023, with this court's decision in Dones, it creates the incongruous result that a youthful offender could be prevented from having to serve a committed sentence at all because they could be given probation, whereas if their position is correct, then a juvenile who was not indicted as a youthful offender could not avoid a committed sentence. And that was never the intention of this court in Dones, I'm sure. And it certainly was not the...
That's what's the circumstances of the three-part YO statute.
Correct. And that was the point. It preserves all the sentencing options for a juvenile, except for when they're indicted, to still receive a continuation without a finding. And as I say, that was baked in as well to 269 Section 10A from its initial writing, because
I think your opposing counsel's argument sort of boils down to the loophole argument, as she called it, is by allowing quaffs in this context, we're essentially, slapping the wrist for serious offenses, and that's inconsistent with 10A. I think because you're allowing just a complete workaround punishment, right? That's, I think, her biggest argument. She's got problems with statutory language, but did the legislature, given how serious it thought gun offenses were, intend them to result in, quaffs with no time in DYS or anything else? That's her basic argument.
well, but the Commonwealth's reading of 269-10A eliminates...
It does create sort of almost a serious penalty or nothing kind of consequence, right?
Well, it does, and it was always intended to, because...
Really for gun offenses. I mean, I understand the statute, but we're trying to discern the legislature's intent here. So they do, for kids who bring guns to school, they intended quaffs, I guess.
Prior to 1996, it's at least an open question. They were, at that point, if a judge thought it was in the interest of the public, they could still keep them as juveniles and assign them to probation. That's written into 269-10A.
Is this a rare disposition in the juvenile court, in your experience?
I can't say that I have heard of. I know of one other case where a continuation was finding, because there's an amicus from that child. I think it's very rarely given, and the facts in this particular case were quite unusual. It was an individual who had an FID card, was authorized at least to possess the ammunition, and he had some exemplary letters. He was temporarily kicked out of school, but regained entrance. And by the time the case was disposed of, had completed, graduated early, and was doing public service while the case ran its course.
So this just speaks to the discretion of the juvenile judge in the juvenile court.
Correct. And in the limited instances where they consider it appropriate, in lieu of an adjudication of delinquency, they should be permitted, and I think the legislature intended for them to have the discretion to give a continuation without a finding to avoid the consequences of a delinquency. Now, and as the court pointed out, the legislature in '96, again, in the revamp of Chapter 119 and the creation of youthful offender, created within it the exemption for certain specific statutes, violent crimes from Chapter 265 that in and of themselves specifically exclude continuations without a finding. That doesn't exist here for people under the age of 18 in the statute that we're dealing with, Chapter 269, Section 10A, which provides for at least assignment to probation for individuals who are not regarded in the transfer context, threats, and in the public interest. The judge could assign them to the custody of the probation department. In 1996, more specifically, that was changed to permit, in my view, the continuation without a finding. But I think it always existed, because obviously continuations without a finding existed in 1975 when Bartley-Fox was passed. CPCS, to their credit, in their brief, has done an excellent job, I think, tracing the history of Chapter 269-10A. And in each of the multiple times in think, 98, 2006, 2014, and even last year, the statute was amended, but it always included that same language of permitting individuals who are under the age of 18 to be assigned to the probation department. And I interpret that as the support for the proposition that's also included in Chapter 119, that in lieu of a delinquency, when it's appropriate, a child's case can be continued without a finding for this offense.
I have two questions for you. They're on different topics. The first one has to do with the actual tender of the plea. So I'm looking at that document, if it helps you to look at that document too. I think I'm on page 12 of the Commonwealth's Record Appendix. In the tender of plea, the juvenile checked the box saying that he was admitting to facts sufficient for an adjudication of delinquency. I take it that your argument is that that admission is not the same as an adjudication of delinquency.
It definitely isn't. It's definitely not in the adult context either. When an individual as an adult or juvenile contemplates offering an admission to sufficient facts, they're proposing to the court that they could be convicted or they could be adjudicated delinquent, and they're asking the judge in lieu of that to refrain from the more severe finding and consequences.
So that in paragraph or subparagraph 7, adjudication of delinquency must mean, in your view, that a determination by the judge or jury, I suppose, if it was tried to a jury.
And I think there's still an open question about whether or not there's any wiggle room on after trial, but we're not dealing with that issue here. To your point, yes, there has not been a finding of delinquency any more than in the adult context. When a judge accepts a continuation of the finding,
So it has to be, so in your view, subparagraph 7 requires a judicial determination of delinquency.
Absolutely. That's why the language in lieu of is baked into the statute in paragraph 1, whereas it restrains or constrains the judge to a 180-day commitment if there's a finding of delinquency.
Okay.
And in that context, the finding of delinquency is.
So my second question has to do with Section 10A and the word prosecutions. Can you give me any help on that? Because how is it that we are to know that that does not include delinquency complaints?
Well, there's several ways. In the context of that paragraph, it refers to anybody convicted in a prosecution for 26910A. It has to be sent, number one, to state prison or the House of Correction. That clearly does not apply to juveniles because those are not sentences that a juvenile is eligible for unless they're indicted as a youthful offender. Number two, the paragraph below that refers the possibility of judges to assign somebody to the probation department for individuals under the age of 18 also exists. So I think for both of those things, whether you regard an action being taken against a juvenile as being a prosecution, the dispositional issues remain the same and available to a juvenile to not commit them, either under the old language, which was there put in place during transfer, or under the new language that exists after 1996.
Do you know if the word prosecution is defined anywhere?
I don't.
Do you know if it's used anywhere else in the general laws?
Not in this context. I know I don't see it in Chapter 119, which raises the inference, at least, that the legislature didn't intend to include that provision of prosecution as referencing adults. But I can't cite you anything specifically that limits it to the prosecution of adults, which is suggested. But the fact that it refers to sentences to state prison and the House of Corrections suggests, at least in that context, the legislature used that with reference to prosecution of adults. And the only other point that I'd like to make is that this was an extremely unusual set of circumstances. The legislature has always, in my view, had this loophole or mechanism to when it's warranted, when an individual such as my client in the Boston Juvenile Court is before the court, hasn't committed any violent act with the firearm, did essentially what we expect in the
But
juvenile.
that goes to the exercise of discretion by the juvenile judge, correct?
Correct.
If we agree with your assessment of the statutory language, and be it as it may, any juvenile judge is able, in a 10A violation, to give a quaff, correct?
Correct.
You happen to have someone who has some extreme mitigating circumstances, but that's not, we're dealing with statutory interpretation. Judge Coyne may have exercised his discretion very well, but this is either a go, no-go, correct?
No, and I appreciate that, although on the same kind of vein, more contemporary thought suggests that there are going to be examples where, for lack of a better term, kids do stupid things. And we look at those perhaps outlying examples as warranting special treatment.
But it's not our place to say to the juvenile court, you have this, there's a statutory scheme, just be careful out there. That's not what we do, correct?
I assume any decision in this case is going to be somewhat limiting in the notion that this is an unusual disposition contemplated by the legislature for appropriate circumstances, and it's reflected in the fact that if there's an adjudication of delinquency, there has to be a committed sentence.
But we're not going to be able to set standards for that type of discretionary call about whether to quaff or not, right? Or are we?
No, but to that point, that's what
So if
law
we
and
have,
trust judges to do.
so if we have an overly lenient juvenile judge who's just giving these out and all the gun offenses, there's nothing we're going to be able to do if we adopt your approach here, right?
No, but there is always going to be a continuum of judges.
No, I'm just.
There are
asking.
other options, clearly, if they're off the rails.
Well, but there usually are ways of bringing people back on the rails, but this is, in the gun area, there may not be if you quaff, right?
I suppose so. I mean, that's the vetting that each judge goes through, isn't it?
Okay.
Thank you very much.
Thank you.